labs were taken.
All right, so y'all need to find that out today.
And then, and then just to give a more complete, the lab that we've found that can retest the blood would require 30 days once they receive it.
Now, before we even get to that point, you all, before you approach me, need to find out where the sample is and if the sample is even in existence. So that's going to be done today. All right?
Okay. We'll come back then.
Yes, I mean, after you all find out where it is.
Okay.
Yes.
Your Honor, would you also reconsider the motion to prohibit the YouTube?
What is happening at the very start of this hearing is a legal dispute that most people watching would not immediately recognize as significant, but that actually has enormous consequences for the case being discussed. The judge is dealing with a blood sample that needs to be located before any retesting can happen. In criminal cases involving drug or alcohol-related charges, the physical evidence collected at the time of the offense has a specific chain of custody that must be documented and maintained throughout the entire legal process. If that sample has been destroyed, lost, or returned to a party without proper documentation, then the ability to conduct an independent retest disappears entirely. And without a retest, the defense has no way to challenge the original lab results. The judge is not going to move forward on retesting timelines or lab arrangements until the most basic question is answered first. Where is the sample right now? And does it even still exist?
Record for a moment. Excuse me, the lady in the black top with the red or burgundy spots on it. Are you on the docket today? Or are you here for someone else? I'm sorry? All right, so you need to move because you're flirting with the inmate. That's not allowed. So you need to step outside. Deputy, remove her. And who were you here for?
Inmate here with the gold glasses.
All right, guy with the gold glasses. And lady, you're flirting with somebody who's an inmate. That means that he's not doing anything for you. And you're down here where you should probably be at work. And if you have children, you should be concentrating on your children. You're not allowed back in the courtroom. You're excused.
And right here, the entire courtroom takes an unexpected turn that nobody in that room was prepared for. The judge just spotted a woman in the gallery who was visibly flirting with one of the inmates and stopped the entire proceeding to address it directly and on the record. She did not ignore it. She did not send a deputy over quietly. She called it out in open court by describing exactly what the woman was wearing, so there was no confusion about who was being addressed. And then she went further. She pointed out that this woman should probably be at work, that if she has children, she should be focused on them, and that flirting with someone who is in custody as an inmate means that person is not in a position to do anything meaningful for her life right now. All of that delivered in a courtroom full of people waiting for their own cases to be called. What do you think was going through that woman's mind as she walked out of that courtroom?
Borrego? Hi, come down.
Judge, I understand he was late. I'm starting up back in a jury trial in one of the district courts here in Bear County. I can't remember, Judge Bettis. And I think he was late. I've not had a chance to confer, so if the judge needs to address him, then...
Why are you late?
We were on the highway. I mean, we're coming. I got up like a...
This moment right here is one of the most relatable and simultaneously most tone-deaf things you will see in any of these hearings, and it lands differently depending on which side of that courtroom you're sitting on. This man showed up late to his own court appearance because he got up at 8:40 in the morning and had to get his kids ready before they could drive him there. And when the judge asked him why he thought leaving at 8:40 was acceptable, he said plainly that he got up late. No elaboration. No apology beyond the obvious. Just a straightforward acknowledgement that he misjudged the time and it did not work out. The judge is not sympathetic. She has been sitting on that bench since before 8 in the morning waiting for cases to be called, and this is the second late arrival she has addressed already today. Being late to your own court date when you have an active motion to revoke sitting over your head is not the way to start a hearing that is already going to be difficult.
8:40, and I had to get the kids up and put their clothes on and for them to come drop me off.
Why do you think you can leave your house at 8:40 and get here on time?
I got up late, man. That's why I got up late.
Yeah, so your children late for school as well?
No, they don't go to school.
Well, what are you getting them ready for?
No, but so we like to put on their jackets because they had to come and drop me off.
All right, there's no excuse for your tardiness. Where are your sober meetings?
I had given she had my he got my paper, the little paper I had. No. I had given
But here, don't get him in trouble. Saying that his girlfriend or his wife has it.
Go. I mean, I got the paper,
But she's not here, and there's another girl. Don't get him in trouble.
But I mean, I did go. I mean, I already got my just for today thing.
No. You need a
paper. I had it with my phone when he put me in handcuffs.
And right here, the judge asks the question that reframes this entire hearing instantly and completely. If you are drug tested today, what are the results going to be? And he answered without hesitation. He used on Sunday. And the judge's response was immediate and direct and showed exactly why she asked the question in the first place. She said they need to take up the motion to revoke right now because otherwise this man may end up overdosing. That is not a dramatic statement for effect. That is a judge who has assessed the full situation in real time and concluded that leaving this man outside the courtroom system any longer without intervention is genuinely dangerous to his life. The conversation shifted in that moment from a probation violation hearing into something much more urgent. And the judge handled it without pausing for a single second.
I had it with my phone.
All right, we're gonna see if it's here.
I got that. And then I made a appointment with Lifetime, and I go on the second. She said if you need a confirmation, it's his father. Yeah.
Let me see it.
Now, does that have documentation on it, or that's just showing that, hey?
No. It's the guy's like process with the A on it.
Well, these are people you to call, but this doesn't show that you actually went to sober meeting.
I forgot to get the paper from them, but I mean, I did go though. I did.
If you're drug tested today, what are the results going to be?
I mean, I'm positive because I used Sunday. That was my last use Sunday.
All right, so we need to take this motion to revoke up now, because otherwise he's going to end up
And then I got
perhaps overdosing.
and then I got an appointment on the second with Lifetime.
All right, so is he going to plead true, or what are we doing?
I don't know, Judge. I have not had a chance to confirm.
Yeah, man.
So
All right.
I've got about 11 minutes.
All right, State. Can you confer with him on Mr. Jacob Borrego on the motion to revoke? It appears that he needs help with his drug addiction.
Yes, sir. You just want to keep him in custody, Judge?
Yes.
I'm going to go finish my trial.
Sure.
And then I'll come back.
All right, everyone, please have a seat. And what date?
26.
All right, Tomas Hernandez. Come forward. All right, your attorney is not doing well. You look better than you did yesterday, but you were still not here at 8 a.m. like you said you were.
8:30, my bad.
No, not your bad. You said you were going to be here at 8. You were
I came on a
not.
little bike, miss.
No, there's no excuses. Here's the thing, what I've learned in my time on the planet. When you make promises, you need to keep those.
Yes, ma'am.
So unless you came from the hospital and some emergency popped up, you said you were going to be here at 8 and you were not. All right, we're going to see you back on the 26th at 9. And Eddie, take care of yourself.
Hello, Judge.
Don't come back down here if you're not feeling well, okay?
No, I had to cut it up from a one-man show.
Okay. All right.
Thank you, miss.
You're welcome.